So there we go. So yeah, welcome everyone. This is the latest Hacks Hackers Real Talk AI Real Talk panel. You're in the right place. To sue or not to sue, the legal battle over AI and journalism. So thanks all for joining. We have a few panelists here who are going to talk about all this, all esteemed lawyers who work in the space. Kevin Goldberg is First Amendment specialist at the Freedom Forum, and actually I have to give a shout out to him because he actually helped Hacks Hackers set up our legal structure initially. So I appreciate that. It's great to reconnect with him in this way. Um, yeah, Megan Gray is founder of Gray Matters Law and Policy, but she also has worked at platforms, including DuckDuckGo. And so she definitely has experience on both sides of this, worked at the Newspaper Association of America. So definitely interesting background. Um, I'm hearing some echo, so if somebody could mute themselves. Also, we have Ashkhen Kazaryan. That is an Armenian name, isn't it? Yes. Sorry for my pronunciation, but at least I know where it's from. Who's a senior fellow at Stand Together, where she spearheads initiatives to defend free speech and advocate for government reform. She also worked at Meta for a while too on doing various stuff. So again, it's a really great panel of people who have worked for tech companies, worked for media companies, know their way around all this stuff. So let's jump in. So I was going to start actually talking first more about the not suing side. So we have to sue or not to sue. Let's start about the not sue. Obviously, more and more companies have been making agreements with tech platforms, OpenAI, Perplexity, other places. Condé Nast last week announced that they were doing a deal with OpenAI. We don't know anything much about these deals, although maybe some people on the call do, but they can't tell us. But anyway, like what I would ask the panel, like for publishers who want to do these kind of deals, like what should they look out for? What kind of terms should they make sure to get in there? How could they maybe limit agreements to make sure they're not giving up too much too soon? I'll just kind of throw it open to all of you to kind of get your thoughts on that.
Well, I think the general consensus is that the publishers that are doing these deals are certainly giving up too much for too little, but they are working on the philosophy of a bird in hand. It's better than two in the bush, and they can get this money now. The outcomes of challenging generative AI ingesting their archives is on copyright grounds is questionable whether that's going to lead to a victory for the publishers. So there's some rational business choices with doing a deal.
I would add that I think one of the foremost things to look at while doing these deals would be the length for which you're licensing this out, right? So we're obviously in this regulatory gray limbo, gray area, gray zone, limbo, twilight zone, whatever you want to call it, uncertainty until courts or maybe executive, like whoever figures this out first. And until they do, it's the blind leading the blind, the lawyers getting paid. But I think from a business standpoint, it does make sense to make a little money now, limit the amount of time you're giving the license for the data information for, and then kind of regroup when we have more certainty in the regulatory space. However, having said that, I think the other side of this is it's kind of a genie in a bottle situation where if you let it out, it's very hard to bring it back in, right? So if data sets of large language models are trained on the Atlantic articles, I, from a just technical point of view, and I am not an engineer or like, like I don't know exactly how it would even be done where you would have to pull back all that data and all that training and delete them. It would be swaths. And I don't know if the models, A, can do that. B, even if they do that, it kind of like loses all the value it had. So that's kind of, there's like that question of how do we even do that needs to be addressed. But I think having said that, the term should be limited. I think that's number one.
So I'll focus on three things that are probably a little more generic and may not have been thought about, but in my experience, especially when working on tech contracts, were always very important. Number one is, and number one is completely generic. Just remember that in licensing situations, if it's not specific, like be very precise in your language. So that's one thing you really need to double and triple check what you're giving away, what you're not giving away. That leads to number two, enforcement. And this is probably one of the more important things that people should think about. The ability to go in and engage in audits to make sure that the contract is being complied with is one you're going to meet a lot of resistance on. And you need to really think, try to be very clear about getting that right for yourself, very strong about getting that right for yourself. Because as we've talked about, you want to maximize what you've got right now, I think, is a lot of what people are thinking. So make sure that you have a strong audit right, that it's a regular audit right. You may end up paying for it, you may not, we'll see. But these are things, of course, that end up being negotiated. And then, because there's always a fight over everything, don't just gloss over things like jurisdiction, choice of law, and arbitration versus a court proceeding. Have conversations internally about how you want to handle those things, because they can, when push comes to shove, be very important to how things play out. And then finally, payment. How you structure payment is really important, especially for small companies. As we've talked about, there's an infusion of cash up front. Okay, that's one thing, but are you leaving money on the table later on? So think about that payment structure, obviously, as a very important matter, and what you're trying to get out of it, what your real goal is in licensing right now. Upfront payment, sustainability, or long-term, protection.
One thing to think about with these deals is we're assuming that these deals are for the archives as well as for future stories.
Yeah.
And that may be a very reasonable assumption. I'm not sure that these deals incorporate all.
Right. I guess I was curious in something that Ashkhen said too, and kind of building on that. I mean, I guess there's a difference between training a foundational language model that kind of just trains using English and just to understand how English works and language works. And for that, I do wonder if the genie is out of the bottle, that some of these models have already been scraped. They understand English now, like it's kind of done, versus like, things like Search GPT, like Chat GPT's sort of search engine competitor, right? Where they want to have it updated every day with something new to be able to tell you like, yes, the presidential candidates have agreed to a debate now, and it knows, I guess that's like a different type of use of the information.
I'm sure there are aspects of that have been adjusted for many of these. With the archive, once it's ingested, it is impossible to extract it again. You cannot unlearn the information. That is the bulk of the value of these deals that can't, even with a 30-day contract term, can be reversed. The value of future data, future news is of course still there, but it's something that is probably less valuable to the companies that they're doing the deals with.
Right. So definitely like, yeah, past archive material, for example, I know the AP deal was limited to the past 2 years of content, right? So they're not giving them.
And you could put into these contracts, we reserve our rights as to anything in our archives prior to 2 years or whatever. And you can have a catch-all provision that says we're doing this deal for X millions of dollars. But if it turns out that the New York Times copyright lawsuit, they prevail, then you're going to pay us $20 million, right? Or that we renegotiate. A lot of these companies have very savvy lawyers, and I'm sure that they're doing the best possible deals that they can in uncertain times.
Right. Yeah, I know the AP said they have some most favored nation clause in their deal, right? That if somebody gets a better deal, they get the same terms effectively, right?
What they're all trying to optimize is we want to make sure that we become the go-to source for users. So not only that you're going to give us attribution or feature us, for example, on your snippets or in your output, but that there's an avenue for us to benefit from this long term. It's not just a singular deal where we get some money here. We also, looking forward, we're going to get data insights from you. We're going to get some sort of edge on our own use of AI. and we have a path where we can increase our eyeballs and readership. Whether that's likely or not, I assume they would know better than I would.
And anything else to address on the licensing side before we turn to all the big bad lawsuits? So let's go there. Okay. So, meanwhile, there's been some, interesting things happening. For example, leaked documents showing NVIDIA scraping a human lifetime of videos per day. These are where people are just going out, obviously scraping the public internet. Websites have been blocking this, using the robots.txt file just to go into that. But then the AI companies, that's sort of an optional thing. They can comply or they don't have to comply with those directions on a website. Scrape it anyway. And what we're talking about here, I'm not going to read this whole thing, and you all don't have to read this either, but go and check out, fair use is really obviously the kind of legal doctrine that is at heart here. Like, is this fair use to be doing, to be going and scraping the internet? Like, obviously people can go and read the internet as much as they want, and read sites that are free if they don't have paywalls. Obviously journalists, rely on this doctrine to, use copyright material, right, in their stories, like, and quoting things, etc., using, sometimes other things, that are part of irregular reporting. So I mean, basically, like, what do you all think? And I realize this could be, it sort of remains to be determined. Like, is fair use, does this cover what AI is doing? Is this adequate? Do we need new laws, new doctrines? What do you all think?
Well, just to clarify, this legal doctrine of fair use only pertains to the input to the model foundation Gen AI company. And they're ingesting this information and learning from it. And then in this magical box that they have, then has output based on human prompts. But the fair use doctrine is really for that input, the training consideration. And that is definitely under copyright, the correct doctrine. Everything is going to turn on that. I think an important aspect here is that that copyright cannot answer all of these questions because it's a collective action problem. If, for example, an AI company has a license to all of the Atlantic and Vox News from the beginning of time until now, the additional value of the New York Times articles would not be as high. And that will impact this fair use analysis because that alters the amount of the copyrighted work. It adjusts the substantiality of the portion used in relation to the copyrighted work. So it's not a perfect vehicle for analyzing whether this is cool or not in our legal system, but it's the only direct analysis that we currently have in how to grapple with this situation.
I want to take like one step back and talk about the dynamics of these lawsuits and the New York Times lawsuit. Or are we going to do that? Are we doing New York Times lawsuit separately, or is now a good time?
We can talk about it.
Oh.
Yeah. I mean,
so the New York Times.
here are all the lawsuits. I guess
Oh,
I put together this list of all lawsuits. If we, there's a bunch of them. Everybody, you don't have to read this tiny print on the slide, but I just go to this link. It's a nice law firm that's tracking all these lawsuits. Yeah.
New York Times, I think, has a gravitas to it because New York Times has been a party to a lot of key decisions in both free speech, case law, and just like overall historically. They have been a party, like they're not afraid to sue. They have amazing lawyers. And what I find interesting is back in 1997, for a case that then was decided by Supreme Court in 2001, the New York Times was on the other side of these dynamics. I think it was New York Times versus Tassini, where New York Times took works of freelance authors, sold it to databases like LexisNexis, and didn't pay the authors for them. And eventually another fun fact is the district court decision sided with New York Times in this case by, at the time, Judge Sotomayor. And then the circuit court and the Supreme Court sided with the independent authors. So now, obviously, Judge Sotomayor is Justice Sotomayor. So when this case makes it to the Supreme Court, it's going to be interesting to see. But overall, I find it very interesting that New York Times is using these kind of concept of romanticized author, like, right, like the fact that authorship brings so much value and it has so much weight and it's important, it should be highly, you know, paid for, where they were kind of like not that long ago, like in my lifetime, on the other side of these dynamics. And that's what I wanted to say overall about kind of how these cases are trying to find the balance between obviously encouraging and benefiting authors and encouraging this like diversity of opinion and to flourish and for people to make money off of their work. But then also there is the other side of, well, these models and this technology is making these great strides in innovation and bringing overall both economically and just societally benefits to us too. So I think it's very interesting balance. And there are two cases that Supreme Court is probably going to be looking at, trying to decide the fair use test here. One is there was a district court decision in 2015 that was, I'm trying to remember, it's like Authors Guild versus Google. That was about, Kevin will give more details than I do.
I'm nodding because I agree with you. This was the one where the Google libraries, right? Where
Yeah,
they
the
were
Google
stealing all the
libraries.
books.
And basically Google won because it said that the like usage or like the works were used for a completely different type of work. And then the other one would be the Warhol Supreme Court decision from a couple of years ago, where basically the result of the work and the original work were too similar to each other. So there was a copyright violation. And so fair use doctrine wasn't applied. This is a very long-winded legalese way of saying there are a couple of different tests that we genuinely can't predict how the courts are going to weigh. Some of these cases are similar to what we've experienced before. Now we just have a greater scale of the AI economy applying to it. So I would be curious to hear what Kevin and Megan think.
Well, I think, you know, and back to the fundamental question of is fair use still the way to approach this? I think largely it is. I'm a big fan of just like, don't rewrite law for new technology. We have something in place. It can be applied. It's more of a, hey, let's see how it works in this way. That's, you know, and that's what we've seen as Ashkhen said, we have a very similar situation in the Google Books case. And if we're going to look at fair use, I think that it's really hard to predict what's going to happen, right? I mean, fair use is traditionally an unpredictable, you know, I mean, moderately predictable, but less predictable standard than some other legal doctrines. It's very rarely black and white. I believe the legal term to be applied is it's squishy. That is one I learned in law school, and I'm going to use it here. Fair use is squishy, because it's not like you get all four. You get all four rarely lining up very neatly. In fact, most of the time, what you have is the fourth one: effect of the use on the potential market for or value of the copyrighted work, and that's what makes this particularly squishy. By the way, we are still learning what these markets are as we're going. I hate the term, you know, building the plane as you're trying to, or flying the plane as you're building it, whatever it is. But that is somewhat what's happening here with the doctrine of fair use in these cases. And that's what makes it particularly unpredictable. What's interesting is that most of the early cases we've seen coming down have been decided in favor of the AI companies. So I guess it's working for them. But I would actually think that based on what we've seen in earlier cases, based on Warhol, which narrowed the scope of fair use, and based on how much we don't know about this, relying on fair use is, you know, I think if you're one of the plaintiffs in these cases, you're like, sure, go ahead. You have the burden. Go ahead and try to make that case. And we'll see, you know, we'll see how it works out for you, especially as we get on in time and we learn more about the market that is evolving in these, you know, in the financial consideration.
I was going to ask, somebody in the chat mentioned this story. Eric Schmidt, said this, and then they like promptly like deleted the video. I don't think you can find it anywhere anymore. But he's like, yeah, just go ahead, tech companies, do whatever you want. Like, let the IP lawyers figure it out later. Basically, I guess that's good for lawyers getting more work, I suppose, being involved in lawsuit, but not maybe the best attitude to have. Yeah, how would you respond to this?
I mean, it's wonderful if you're a successful tech company. It's also honestly, look, it is, by the way, the video, I saw someone in the chat say the video's up. There's a full transcript that you can still find. I
Okay.
can't remember where it was, but I read it and confirmed those remarks. This is actually the way the world works more often than not. I mean, in the legal world, when I was in private practice, I wasn't representing the Googles, Microsofts, big companies of the world. I wasn't even representing the New York Times and Washington Post. I mean, I had the smaller local companies who often, had this attitude thrown at them all the time, whether it was attacking us and saying, we'll sue you to get what we want, or saying, go ahead and sue us, you don't have the money. That's how things work. And obviously, from the perspective of a startup tech or journalism company, it's not a great situation, but it's reality. And that's one of the reasons I say, like, dig into those contracts if you're going to make those deals and get the enforcement part right, to allow you to actually get some leverage if you actually have to go to court. Because they'll just, these firms will just, these companies have the best firms going. I mean, you look at that list. There's another list that I found, which actually lists the counsel for the tech companies, for the defendants in a lot of these cases. I know some of these people. I know these firms for sure. They charge a lot of money, but they have a great legal teams, as Megan and Ashkhen have both acknowledged and said. That's how it's going to go. That's how it's always gone. That's how it's going to go.
Yeah, I think Schmidt's only concern here is that he said the quiet part out loud.
Yeah.
Like that, it's ridiculous to think that the world operates in any other way than how he described it.
Yeah, move fast and break things.
I also appreciate kind of the quiet part out loud, because at least we're not doing the like theater of concern and like, we run this company for social good, which I find to be 9 times out of 10 not true. If companies are more honest about how they do business and why they do business, similar to when Zuckerberg said, like, we sell ads, right? Like, Senator, we sell ads. Like, I think we would be better off just trying to understand, especially for the general public, how the dynamics in this space work. I also think that overall, when it comes to journalism, there is a lot of problems that already existed in the journalist space when it came to revenue and supporting independent journalism, and just overall the business of journalism has changed. And I think already there's so much tension between newspapers and more traditional media and social media. So we just added like a third power player, sometimes overlapping with social media, sometimes not, but the AI companies. And then the other thing I wanted to say was that this is completely not related to AI, but stay with me. The Disney scandal of a man suing them, and then them saying, you had a free trial like 5 years ago for a month, and you can sue us, we've got to go to arbitration. The reason I'm pretty sure that's going to work out for him is because we had public's attention to this unfair balance that exists that the lawyers have created. And I think we just need to have the societal pressure, attention, and educate the society about the dynamics of this space between, independent journalism and just like overall media and tech companies, and then go from there. If we have enough eyeballs on this issue, I think it would be more fair, because sometimes you might even win in court, but you don't want to win in court. You're going to settle because you don't want the brand reputation to suffer. So,
well, I mean, and I mean, that's a great story with Disney. I think with Google too, in the early days, it's important to remember that this strategy is exactly the one that they implemented with their book scanning project. And it was a successful strategy for them. It was also the strategy when they acquired YouTube. In the early days, it was questionable whether YouTube had some completely defeating copyright issues that would prevent them from operating. And YouTube was successful, right? So
They actually, I mean, they came up with a really creative product solution, right? They're fine. People are ripping off music, putting it on their videos. We'll help the music companies find it out and then go and get licensing fees from those videos, right? Like,
right. So, I
Yeah.
mean, it worked out in the end. Nobody at Google said, hey, let's stop. Let's get some clarity here. Let's make sure we've got the copyright clearance rights before we go further. And nobody does that. That's especially when you have so much competition trying to grab mind share and market share as quickly as possible.
It's
Yeah.
the George Costanza. It's like, wait, was that wrong? I'm sorry, was that wrong? I didn't know. You know, that kind of has pervaded in these companies for a long time. I will not sidetrack you. So Megan, don't pick up this thread, but I recommend that you look at some of the stuff she's written about generally how, you know, what's happened in court cases involving some of the big tech companies, either on her Twitter feed or in her articles, because it's, you know, as I said, I'm not picking on the tech companies either. It just happens that bigger companies do this a lot to smaller companies. It's a reality. And sadly, yeah, he said the quiet part out loud, and we just have to understand that is not a level playing field. It never will be a level playing field. So what can we think about what we can do to level the playing field?
Right.
I was wondering, I mean, there's been this case says they've been making progress. Like, is there a difference between art, imagery, maybe more opinion, novels, fiction versus like news, because that's like fact and it's not as copyrightable, I guess. Yeah, information.
I don't know.
It-
This fact. Have you like watched Fox News? Sorry. Just to get that out there.
for the fair use analysis that you were walking us through, it makes a big difference. Because it's a question of what is how strong the copyright is. If your article is mostly facts, then the copyright protection for your text article, news article, is going to be a fairly thin copyright. Copyright protects expression, not ideas, not facts. So it is visually easier to understand creativity with, I think, images. That doesn't necessarily have to be the truth, but I am certainly much more of a textual person. And so when I see a painting, I'm like, wow, how did somebody do that? As opposed to even a fictional article doesn't feel as foreign to me in a creative process. But for AI, I don't think the legal analysis is any different. It's just, it's the same factors on fair use. It's just when you're applying them, it can have a different outcome.
Yeah, and I mean, you know, to kind of go back and reiterate something, fair use is a defense. So these companies have to meet the burden there. I mean, all the plaintiffs have to do in any of these cases is show a copyright infringement occurred, which is really simple. You have a valid copyright and someone else did something substantially similar. Good. Now you tell us if you have a license or some other or fair use or it's in the public domain, just any reason you should be allowed to take our content without our permission. And as Megan said, in the fair, you know, so in the fair use context is really where it's going to come into play. Once you have an original work of authorship fixed in a tangible medium of expression, you have copyright. It's in fair use that you start looking at more of the gradations of how this occurs. And yeah, there will be differences as you get more creative. The Warhol case, part of what the court said was, you know, you kind of just had a standard picture photograph. There wasn't a whole lot to it that was starkly, I disagree, but there wasn't a whole lot to it that was starkly, you know, unique or creative. So, but I mean, so I think that that is where those differences may come into play. Obviously, let's also shuttle off facts. It's been pretty clear that facts and ideas, as Megan said, are not protectable. And there's a case for that too. There's a case for everything just about. NBA versus Motorola from 1997-ish, where the NBA, this was early on, and the NBA was trying to keep like real-time reporters out of arenas and all the, under a copyright theory largely, and a hot news theory, but they basically said, look, you can't, you're disrupting our exclusive broadcast partnerships. And, we can't have that. We're going to sue you. And Motorola, which put these reporters in with these little devices to feed real-time stats to fantasy, basketball enthusiasts, were like, what are you talking about? We just have people in the stands and they're sending out facts and nothing more. You can't keep us from doing that. And the court sided with Motorola on that aspect of it, saying, yeah, these are just facts. They're not copyrightable at all. So I mean that there is a clear legal distinction for that.
Okay, I wanted to start getting into some of the questions here, and there's been some in the chat, and I'll raise some of them. If you have any questions too, please feel free to put them in the chat. And Paul, who's my able co-host, will help surface them to me too, so I don't miss them. So yeah, Madhav did ask a question going back to kind of the licensing issues. He was wondering if the term, I mean, you talked about a time period in terms of like, restricting the use of content. He actually wondered if you should restrict it based on per like AI model use, like GPT-3 for, I don't know, if 040 or what, like, how do you break down what is a fundamentally new model for?
Yeah, you absolutely can, but it gets back to Kevin's point, which is how are you going to monitor that? I mean, they keep those cards pretty close to their chest. Unless you get on site and start doing depositions of engineers, you're going to have a very hard time knowing when your content has been inappropriately used for a different model.
And they aren't going to turn it over easily.
Yeah.
We also live in an age of data brokers who have swaths of data they've been selling for like years now. And we don't even know what kind of, that's all another black box that goes into other black boxes and exists in the context of another third black box. So it's incredibly hard. And I don't think anyone would succeed on a great scale of like unveiling what company, what large model has what databases and what data overall and information that they've trained on.
It's not an unusual situation though for licensing to have different in blanket licenses to have different degrees of blanket licenses, either for different users or for different data sets, and in any event. So yeah, I mean it's perfectly, if it can be done and enforced, it can it's not like there has to be one license and that's where you stop.
Sure.
I see we're getting some chatter back and forth here now about this idea of ingesting. Is it copying based on what the outputs are, etc.?
Yeah, I mean, Adam raises a good point in the chat, is the idea of, for training, is that quote copying as it is understood under the Copyright Act.
Yeah.
And there's an argument to be made there. It is, a long time ago, we made a very key distinction in copyright law of whether content was written to disk versus held in memory, right? Which are computer terms that are not as distinct as they once were. I imagine the courts are going to have to address this in the Gen AI cases that we're going to see coming down the pipe, but I don't think they're going to have much difficulty with accepting the proposition that this is a full ingestion copying of the material. And the question ultimately is going to be fair use.
Well, and there's some other issues. I mean, we've talked about going back. I'm kind of sidetracking, but I think the question of copying is one way to bring this up now. There is a kind of interesting side note within the New York Times case, I believe it is, where the defendants are basically saying we need access and discovery to your underlying data sets so that we can take a look at what you claim we are copying. And the Times has responded and said, whoa, you know, reporter's privilege. We're not letting you into our underground like layer here. That's pretty clear. So that brings up a lot of really interesting issues, both as to whether it is and how you'd prove it and where other lines will be drawn.
There's a question here from Tyler Dukes from McClatchy. How does the argument over copyright infringement compare to other massive scraping efforts like Clearview AI and all the, you know, I guess everybody's own portraits that have been taken from Facebook and everywhere else?
Yeah, we've seen this a couple of times with the mass digitization, for example, in Google Books, or with the mass photo grab by Clearview AI. The Clearview AI one, I think, is more of a practical situation of knowing, identifying who is the actual copyright owner. Because just because it's a photograph of you, that doesn't mean it's a selfie. It doesn't mean you're the copyright owner. So, you know, deciding how to pursue a copyright claim there is challenging for a lawyer, because you don't even know who to pitch to who you want to be your clients. We have seen, even at the Supreme Court level, how they want to handle the idea of large-scale digitization. And generally, until recently, they haven't had any problems in evaluating it in a standard copyright analysis. The challenge now is that the new concept, the new undecided aspect of these cases is going to be that there's no reversal here. It's a learning model where it is very difficult to know what, if you have learned everything in the world, you know, how do you segregate out the copyrighted content from the non-copyrighted content, for example? How do you segregate out the value of the New York Times copyrighted content versus the YouTube content? So it is not the same. It's not ultimately going to be the same, but we haven't, I think the idea that a lot of people take, oh, we've already decided this with Google Books. It didn't raise the same issue at all. So.
Another question surrounding facial recognition and AI that I'm more worried about, and I think we need more attention to, is government use of facial recognition technology and ability to now use at scale scanning to violate our privacy rights in settings where we expect to have them. And I think it's already happening, you know, at a great scale at airports, because, you know, you'll consent to anything just to get through the line faster. Speaking for myself. But it just overall, it's actually creating a lot of serious issues. There's a lot of great work that was done by Georgetown scholars about basically how in a lot of criminal cases, an eyewitness will say, oh, the suspect looked like Tom Cruise, and then government would use a picture of Tom Cruise and run it against pictures of like everyone in that area who kind of looked like Tom Cruise and make arrests based on that. Obviously, you can see how the equities here would be against minorities, and you know, so it's just like another big Pandora box that I would want to open at this discussion and just say, yeah, commercial use, our faces, you posted a bunch of photos on Instagram, that's bad. What's I think worse is government use of it.
Can I interject something really quickly here, because I feel the need to? We were talking beforehand, and I don't want anybody, at least I'll just say it for myself. It seems like an appropriate time to say it. I don't want anybody to think we're anti-AI. At least I know I'm not, or even anti-tech companies like you know, on the fair use issue. We were talking about this beforehand. I mean, I'm a First Amendment advocate first and foremost. And so you would presume I come from the side of, yes, fair use, you know, let's create, let's build, free speech. We're gonna put it all out there. And I will say that actually I'm probably not. What brings me back to the middle is I'm very much pro-creator. I really think we got way out for a while until especially Warhol, you know, ahead of ourselves in allowing fair use. I thought it got actually way out of control. And creators were just lost in the shuffle. So I don't know, I just feel like we've gone to a place where we've been a little negative in this. I mean, I want to see this work. I want to see it all work. And I think there should be a balance if we can get there. I think, again, it's leveling the playing field. I don't want to put that in front of you two, but I just want to be clear about that.
No, I think that's absolutely true. I don't have a position on this. I don't know whether it would pass muster under copyright fair use analysis or not. I also think that it's very simplistic.
I'm going to defer that and say that we did discuss this before y'all joined us. So yeah, none of us do think that there's a right or wrong side. The balance is just off. And as I was saying in the beginning, it is important to take into account all the benefits that we're already experiencing as a society that come from generative AI technologies. It's just a very gray area, both legally and policy wise. And if anyone is telling you they know all the answers on this, don't trust them.
We don't know anything.
There was a question before the panel started, like, how do journalists use AI without being sued? I guess the concern, yeah, if you're using it to like, write headlines, create images, I suppose, yeah. You know, what's the worry there too?
I mean, this is where I come at it first and foremost. This is where my worry about AI comes from, is how it is, you know, again, how journalism might once again find itself another, you know, financial leg chopped out from under it. We all remember what happened at the beginning of, you know, the internet and journalism in the internet era, and what was given away and lost and never returned, and how that, you know, in part has helped lead to where we are today in journalism. And I don't want that. I don't want that because it's not going to just sort of continue to creep up. It's going to accelerate. That's my worry. So I do understand this issue. And from the side of journalism, I just say it's another source. I would use AI as another tool and another source, but it doesn't mean it's the same as the legal profession. It doesn't mean you use it and you think it's right. All right, actually continue to do the work. It can be a wonderful tool. It can be a wonderful shortcut. It can be a wonderful research aid. It can help make your work so much better. It's been doing this all along, right? We've had various functions of low-level AI checking things for us all the time. We also then check up on it again. You do one more pass, right? I mean, I guess the best way I could explain how to do it is taking it out of journalism into the legal world, where some states and courts have passed rules that say lawyers cannot use AI to draft briefs. And my view is, why? If they want to run that risk, run that risk. You know, you want to put yourself out as a fool, put yourself out as a fool. I wouldn't do it, but some people may need to and may be able to you know, you engage in more use than I would. So be it.
English is my third language. Everything I write, I now run through a large language model to make sure there's like no typos, their punctuation is right.
Yeah.
It just makes my life so much easier and faster. I don't think here's the thing. I think I still own, like, that's still the work that's written by me. If you're telling me I missed 2 commas, like, it's not ChatGPT that owns my work.
And from a copyright perspective, I'll say is the biggest issue. Like, if it pulls stuff for you, you gotta, especially with visual. I would say visual is the most important thing. Don't rely on any visual that's pulled, any art, because my rule is, if you didn't create it and you don't know you own it, then you better confirm that you have the right to use it. And I think that's where you can get tripped up as much as anything.
Okay, yeah, there was a question, I guess, and this is dovetailing on what we were talking about earlier too, from Dylan Friedman of the New York Times. In the music industry, it seems the legal standard for copyright is more stringently applied than text, like litigation for similar beats or melodic lines. I guess what the Ed Sheeran, Marvin Gaye case, I guess, is the one that I'm thinking of recently, right, that happened. Why are the standards different? And would the music AI generators lawsuits face more of an uphill battle?
Well, it can. I mean, the standards are not different, first off. I mean, in terms of copyright protection, we get back to the same concept of whether this is a thin copyright or not. Thin copyright is only, it is the term that we use when it's mostly factual and therefore does not have the expression aspect, the creativity aspect that copyright protects. This is also true for scenes of fare, which is a term that means that scene from, we can say that was from, you know, Romeo and Juliet. The idea that you, this expression that you have is not really all that creative because we have seen it a million times before. And you do see that with some musical copyrights. But I don't agree with the basic premise that there's a difference, just depending on whether it's auditory or written or visual. It's the same copyright metric on deciding whether or not and how much something is protected. It's just, I think we as humans often have a harder time recognizing the creativity aspect when it's factual information.
I will disagree with Megan, maybe make this finally like more exciting. But I don't disagree on the like analysis of it. I disagree on the politics and dynamics in the industry, because the music copyright industry complex has been one of the most powerful lobbies in Washington, D.C. You have ever seen. And it's kind of like a silent killer in a way, where they will pass, with all the love to my friends who work in that space, they will pass legislation unanimously through both chambers, which is like unprecedented on many levels. And they would, you know, monetize, and whatever money gets back to the actual musicians is a question, but the record labels and the ones who hold the licenses to the music definitely benefit. And my other favorite kind of anecdote about the music industry and AI right now is Grimes, who is a musician, I'm told. When AI had like their boom in December of 2022, first said on Twitter, everyone should use my work, and however they want, I'm giving you a blank, you know, license to do that. A week later posted and said, hey, how about I get like half of the money off of it? And then a week later said, my lawyers told me to tell you to stop doing this. We're actually going to reevaluate this, which was, I think, the perfect example of both the chaos, uncertainty, and also the power of the music industry.
I should probably stay quiet on this, and I will definitely have to mark my words, because between private practice and working at the Freedom Forum, I spent 2 years as a general counsel to a trade association in the music industry that represented the major platforms. So I really am going to be quiet. I will just note that as Ashkhen kind of not insinuate directly on this, but consistent with what you said, some of the lawyers we used on a regular basis and that were used by the biggest platforms in the world are also now representing the OpenAI and other companies in this litigation. There are only a handful of firms that are top-notch copyright firms, but there are also a lot of the, you know, there's a lot of similarity across that world. There is a lot of power in that world. I think one thing about the music part of it that is maybe a little different, at least the music lawsuits, is there are other avenues that can be used to attack for the music companies. First of all, I do think that there might be a little more power on the musician's side, also a little more weakness in a weird way. There's a little more power in that you know, some of the musicians have a little more, the bigger labels certainly, and copyright owners have more power obviously than some of the journalists do, and they have their own great lobby that works very hard on behalf of the songwriters. So there's a little more stability there.
But I don't think any of us agree though about what copyright law itself does not distinguish between different mediums of content.
Well, there are separate sections entirely for music.
Yeah, you can break down the bundle of copyright, but the question of whether or not something is protected by copyright and how you do the analysis on fair use, it's not different. Now, the question of political power, yeah, you're absolutely right. I mean, for example, I don't see a lot of political power being exercised by tattoo artists, but that is an entire industry. There's jewelry actually doesn't have a very powerful copyright copy, but it should. There's all sorts of examples like that. But I don't I don't expect the newspaper industry, unfortunately, has not shown itself to be as savvy of a litigator with that in this particular context. Not yet. And I think it's because when we started this panel, we talked about why are some of these companies doing deals and others aren't, and what are the considerations and pros and cons of that. I mean, one of the considerations is that certain companies can free ride off of the litigation efforts of companies like the New York Times. They can grab the money now and just like, well, we don't need to fight that battle. The New York Times is going to do it for us.
And some of them may want to. As I started to say a little bit about music, one thing that makes it unique is that there are going to be other avenues from, to attack that aren't strictly copyright either. There's other causes of action you could bring, like right of publicity, things like that, that are going to be very helpful. And I will note that back to journalism and AI, there may be a few that I think could really crack the door open. And some people might legitimately be waiting on. And one of those that has not been fully successful yet would be the DMCA claims we haven't talked about. Because those are, if you find it, kind of a smoking gun. And would really, and I think they're things that would easily be transferred from plaintiff to plaintiff much more easily than fair use. So that, there is a similarity in going out, or a difference, but a similarity in going outside of just straight copyright infringement that I think exists between the industries.
Yeah, no, Amy from the AP, who does work with AI there, noted how the music industry is united. News organizations seem to be kind of going it alone. There was talk of getting everybody to band together. I mean, there was talk of the whole news industry banding together back in the 90s at the dawn of the internet and web to figure this stuff out, which did not come to pass. So I guess, yeah, that history has not gone well for the news industry.
Well, there is a fundamental difference in that copyright law as pertains to music does in certain circumstances allowed for that kind of coordinated effort in a way that other areas of copyright law or other industries don't.
Yeah. There was also John Acarino brought up, and this is going to be one of the last things I get to before we wrap up. Some startups have offered platforms to help people monetize their content now, right? Where they will kind of, take all your content, do the brokering for you, I guess, figure out how it's used and figure out fees. I don't know. Yeah, kind of creating a marketplace over this. I'm curious, how you all think about that, or have you looked at
I
any of
mean,
those?
you can also upload all of your photos to Snapfish and give them copyright and Getty Images. I mean, these ideas are the business concept is not new. I
guess
don't.
the training, I mean, this was also something that came up in the chat that like copy, directly, yes, using a photo of whatever, I mean, is one thing.
Where you could monitor it, where you could audit
Right.
it, you could get records. How many times was this used? In theory, you could get like, where was it used? How many times was it copied? But with the platforms being generated now, where you can upload your content and say, okay, let the riches start raining down on me. Even if you were to get some residual money, at a steady pace over time, you're not going to have any idea how accurate that is.
I want to mention something. And it's slightly unrelated, so I apologize, but since we're wrapping up, one of the biggest memories on my first kind of face-to-faces with internet policy when I was still in college was the battle between the internet companies and a lot of the civil society against the copyright lobby over SOPA and PIPA back in 2000 and 10, 9?
I don't remember.
Like some of you might remember, like Wikipedia, a lot of these websites had like a blackout day. It was a whole thing, and it was about access to information and freedom of speech, and also making sure that the copyright systems are not violating and silencing and overall kind of messing with the scale of freedom of speech online and chilling it. So I think that if the copyright industry or even the media in a way try to band together and go too far, they might have a similar backlash happen. So just bold prediction, but if there is a world in which, you know, there is one polarizing side, there will be a counter to that.
Very valid point indeed, yes. John says never accept a rev share deal. I guess like Perplexity, it devalues content. Yeah, I guess there's different models definitely to use for this. Any final thoughts from you all as we kind of wrap up here on this thing? Things to look out for, where you see this going? Oh, Megan, you're muted.
Sorry, you'd think I'd learn. I'm most interested in the exclusivity aspects by the large companies. Right now, for most AI models to function, they're very expensive propositions with all the cloud and energy requirements, which means that it's almost inherently concentrated with very wealthy companies. And it's interesting to me that some of the deals we're hearing about by the news organizations is, okay, we've done a deal with OpenAI, but not with Google's Gemini. And that means we can, you know, we can go to the next company and go ka-ching the next time we decide to fill the coffer. And I'm just not sure that that's going to work out well because of other macro aspects here, where, for example, with the antitrust cases against Google, whether they're going to end up being able to exploit AI in the same way that Microsoft may be able to. And I also question whether it's going to be that distinguishable. I think a lot of these models are starting to feed on other models. And I think the news organizations are probably calculating this as best as they can. I am sorry that they did not keep a unified front and try to do this collectively, because I do think just generally all of this raises collective action issues. I wish they would make it public what some of these deals are. So even if they've decided it's in their best interest to do a deal, it's up to them on whether or not they keep those terms confidential. They don't have to insist on that. And if they wanted to contribute to the health of the industry, but are not willing to commit the money to pursue litigation, for example, maybe one way that they could be good citizens would be to be more transparent on what these deal points are.
Go ahead, Ashkhen.
Sure. My very quick final thought is, while we are focused on very thoughtful debate and kind of following the developments as we go and trying to figure this out as a society and a legal system, Europe is just legislating. Along with Australia and a couple of other places, and international bodies like WIPO, is that how you say it in English? WIPO. They're way ahead. They have no doubts. They have a lot of confidence. They know what to do is right. And I think with the bigger like generative AI companies, they're going to want to comply with that. And they're actually collaborating with the regulators in Europe because they're kind of coming in and they're saying, listen, we don't have bad blood like the tech companies. We want to work with you. Slightly sounds like regulatory capture to me, and trying to adjust the terms to how they already feel comfortable operating. But just keep an eye on that, because while we're trying to figure this out, that might come in, and if the bigger companies just comply because it's easier to comply globally, might become kind of not law of the land, but like the way we operate here too.
Well, you've raised a couple interesting points I was going to wrap up with as well. One of which is we haven't even begun to scratch the surface of this, because we haven't talked about international, right? I mean, which is just like dominating everything. I will point out one thing I wasn't going to talk about, but you put right in front of me, is there is a precedent for that back to the music industry. I mean, the current framework for streaming music royalties is found in Section 115 of the Copyright Act, the Music Modernization Act. And that was really the product of just litigation fatigue over years and years and years. Granted, and you could see the same thing coming down the line. Now, The horror of that is it took like 10 years for the Music Modernization Act to get passed, and I don't think we have time to do this here. I just don't. Yeah, there's no way. We are at a much more accelerated framework. The problem is, I think if you're going to look at where this sort of plays out, you have, I think, a little more legal leverage. I still believe this lies with the plaintiffs in this case, lies with the journalism companies, lies with the content owners, but they have no power to make it happen, as going back to what we talked about at the beginning and Eric Schmidt's remarks and everything else. And that's really going to be tough to see how that plays out. I will point out in closing, a lot of the articles I looked at talking about settlements and licensing agreements, you had the content owners talking about what a wonderful partnership they were engaged in. And I was like, that's just spin for, we're just happy to get what we could here. I do not see any of that as a real partnership. It's tough. It's like, we got what we could, and hopefully it's going to work. So yeah, it's a fraught period. I think to see where this goes next, it's a real inflection point.
Yeah, thank you. I wanted to thank all the panelists for all your insightful comments. I definitely have some interesting ideas and follow-ups out of that. This, just to tell all of you here, this is the latest in our series that we've been doing, the AI Real Talk series from Hacks Hackers. We've been saving videos, and we will post the video of this talk as well at our YouTube channel. If Paul was going to maybe share that in the chat, the link to that. Also, we do have the next talk in this series coming up, focus on elections. Is the first AI election an opportunity or a nightmare for democracy? That's on September 10th. Yeah, so Paul will be leading that with some great panelists as well. So yeah, thank you all for coming. Hope to see you again soon. Have a great end of your summer.